Hello, welcome to Legal Advisors World. My name is Toluwani Mercy Francis, and here we answer your legal questions in the most simplified manner. I would like you to subscribe if you are yet to do so. I would like you to like this video. I would like you to comment, drop your comments in the comment section, and share this video. Thank you for helping us grow this community. In this particular video, we'll be discussing about classification of offenses, which is a continuation of our series on criminal law. If you've not seen our previous videos on this, please watch them. I'm sure you're going to learn one or two things. Yes, about criminal law. Without further ado, let us dive right into the video. Yes, welcome. This is Legal Advisors World, and today we'll be discussing classification of offenses. Please, if you see me look down, I have a note here on my lap, and I may be glancing at it from time to time to ensure that I don't miss out on important points while discussing this very important topic. Classifications of offenses. Offenses can be classified in various ways. Offenses can be classified, one, according to the objects of the offense. That is, whether the offense was committed against a person, for example, rape, whether the offense was committed against property, for example, arson, that is when a building is burnt down, or whether the offense was committed against the state, that is when you have a victimless crime, for example, riots. Nobody has to be injured in the riots for it to be a crime. The presence, the action, that riot itself is a crime. So that is an example of an offense against the state. So offenses or crimes can be classified according to the objects of the offense. Another kind of classification is according to the content of the statute, according to the content of the statutes involved. For example, NDLEA Act deals with drug-related crimes, for example, drug trafficking, production of fake drugs, selling of fake drugs, and all of that. While EFCC Act deals with economic and financial crimes like money laundering and so on. So crimes can be classified according to the content of the statute that regulates that sector, that regulates that area, that regulates that subject matter. A third classification is according to the mode of trial for the crime, according to the mode of trial, yes, whether the trial can be conducted summarily or whether there is a special procedure to be followed, like an information and so on. So that is also a, a manner in which an offense can be classified. A fourth classification for offenses is according to whether it is a common law crime or a statutory crime. If it's a crime or an offense prohibited by common law, then that's a common law crime. If it's an offense prohibited by a particular statute, then that's a statutory crime. Yes. And the fifth classification, which in my opinion is even the most important or the most popular, is according to the punishment attached to the offense. Yes. The criminal code in section 3 categorizes of offenses into three different categories. It splits offenses into three different categories. The penal code does not have this kind of classification, just the criminal code. You need to take note of that. In section 3 of the criminal code classifies offenses into one, felony, two, misdemeanor, three, simple offense. So an offense can either be a felony or a misdemeanor or a simple offense. A felony is any offense that is punishable with a term of imprisonment of 3 years and above, up until death sentence. So if the offense attached to a crime is a term of imprisonment of 3 years plus even up until death penalty, then that's a felony. Any crime that satisfies that is a felony. Secondly, misdemeanor, a crime that is punishable with a term of imprisonment of between 6 months and 3 years. That's a misdemeanor. So if the term of imprisonment attached to a particular offense is 3 months up until 3 years when felony starts, that is a misdemeanor. While a simple offense is an offense that is punishable with a term of imprisonment of below 6 months, like less than 6 months. That's a simple offense. We have traffic offenses are usually in this category, yes. So that's a simple offense. And these classifications, they have their own consequences, right? There are procedural consequences and there are substantive consequences. Yes, there are procedural consequences to this kind of classification, especially this fifth classification. and there are also substantive consequences. On the list of procedural consequences is one, the power of a private person to arrest is more liberal in cases of felonies. So not only the police can arrest under the Nigerian criminal law, private individuals can also arrest. However, that power to arrest is not so it has its requirements, yes. So the power to arrest is more liberal. A private citizen, a private individual can actually effect an arrest, is actually allowed more to effect an arrest in cases of felonies when a felony has been committed or when there is apprehension that a felony is about to be committed. That is the if number one procedural consequence. Another procedural consequence is that the power of a private person to prosecute is limited only to cases of felony. You know, when we were discussing, when we were introducing criminal law, I mentioned that crimes are offenses committed against the state, and the prosecution is handled by the state, by the Ministry of Justice, by the Attorney General of the Federation, or the Attorney General of the state, you know, who assigns the matter to the particular lawyer from the ministry who will handle it, government lawyers, right? But the law also allows for private lawyers, lawyers who are not government lawyers now, but if they apply for what something that we call a fiat from the Attorney General grants them that fiat. That fiat is like consent to prosecute. A private individual can apply for a fiat to prosecute a crime or to prosecute an offense, but only if it is a felony, right? You can't apply for a fiat to prosecute a misdemeanor or a simple offense. So that right of private individuals, private lawyers to apply for fiat to prosecute is limited to felonies. So that's another procedural consequence of this classification. A third procedural consequence of this classification is when the act is that whenever an act constitutes both crime and civil wrong, if it's in a case of felony, the felony will take precedence. Like the prosecution of the felony will take precedence over the civil suit. Yes, if there is a reason to make a choice of which goes first or which takes precedence, which is more important, the criminal trial is more important. It takes precedence over the civil action. Yes, I hope you understand that. If you have questions, you can drop them in the comment section. That will be all for procedural consequences of this classification. There are also substantive consequences of this classification, especially that fifth classification of felony, simple offenses, and misdemeanor. Yes, the first substantive consequence is that it is only in respect of a felony that there are subsequent offenses. Usually, when you see a felony, there are subsequent offenses like compounding, like like neglect to prevent a felony. Compounding is also an offense on its own. Neglect to prevent a felony is like a subsequent offense to that is available only for felony. So compounding, there can be compounding in cases of felony, and then there can be neglect to prevent a felony as an offense. So felony as an offense attract additional offenses or subsequent offenses. That's the first substantive consequence. Another substantive consequence is that punishment for attempt or conspiracy to commit an offense varies between the various classifications. Felony attempts are more serious. Punishment for attempts, for felony attempts are grievous, are more grievous than the other uh, classifications like simple offenses and then misdemeanors. Yes, conspiracy to commit a felony has more grievous punishments attached to it than others. I hope you understand that. And lastly, for under substantive consequence of this classification, there are a number of defenses to public officers or even private persons who have the power of arrest. So if you are exercising your power of arrest as a police officer or as a private individual who has just witnessed the commission of a crime, or you have good reasons to be apprehensive about the commission of a crime and you make an arrest, you have more defense. Like the person who you have arrested, maybe in the process of arresting the person, and the person is now claiming assault, whatever. you have no defense at law. That is if the crime that has been committed that you are making the arrest for is a felony. I hope you understand that. If you have questions, maybe there's something I mentioned that you do not really understand, you can drop your questions in the comment section, and I'm going to try my best to explain for them. Yes. So if you are a law student, I hope you got value from this. If you are just an individual who is interested in learning the law, I hope you also got value. I just want you to know that offenses have different various classifications, and their classification, those classifications have consequences. Yes. So the way a felony is handled is not the same way a simple offense is handled, is not the same way a misdemeanor is handled, even though all are crimes, and the burden of proof for all of them is to prove beyond reasonable doubt. The law takes everything serious, but the one is weightier than the other. A felony is weightier than a misdemeanor, while a misdemeanor is weightier than a simple offense. You don't expect the law to punish someone who ran a traffic light, like who didn't stop, who ran a traffic light and committed the traffic offense, to punish the person the same way the law will punish somebody who has just murdered someone. Murder is a felony. That running a traffic light, that traffic offense is a simple offense. So, which may just attract maybe fine. If it's in a serious case, maybe a term of imprisonment, which may not be more than 1 month, which definitely will not be up to 6 months. So that's a simple offense. I hope you understand everything that we have discussed. Like I said, if you have questions, please drop your questions in the comment section. If you have other things you want us to discuss, other subjects you want us to discuss, you can also drop them in the comment section. Please share this video, subscribe, like it. I call you blessed.